Putting your IRA in a trust sounds smart, but it can cost your family a fortune in taxes. An IRA is one of the most valuable assets you can leave to your family. But how you leave it matters enormously. Naming a trust as your IRA beneficiary can create a serious tax problem your family will have to live with for years. Here is why. Before 2020, beneficiaries could stretch IRA withdrawals over their entire lifetime. That spread the tax bill out over decades. Then Congress passed the Secure Act. That law eliminated the stretch for most non-spouse beneficiaries. Now, most people who inherit an IRA must empty it within 10 years. That 10-year rule applies whether you name a person or a trust as your beneficiary. But when a trust is named, the tax consequences can be far worse. Here is the problem. Trust income is taxed at the highest federal rate, 37%, once it exceeds just $15,650. An individual does not hit that same rate until income exceeds $626,350. That is a massive difference. If your trust holds IRA distributions and does not immediately pass them to beneficiaries, the money gets taxed at trust rates. That can cost your family tens of thousands of dollars in unnecessary taxes, or more. There is a special type of trust called a see-through trust. If it is drafted correctly, it can qualify for the 10-year rule that applies to individuals. But it must meet 4 strict IRS requirements. It must be valid under state law. It must become irrevocable at your death. All beneficiaries must be identifiable individuals. And a copy must be provided to the IRA custodian by October 31st of the year after your death. If any requirement is missed, the IRA may have to be fully distributed within just 5 years, creating an even larger tax bill. Even a correctly drafted see-through trust is not always the right answer. For most people with straightforward family situations, naming individuals directly on the IRA beneficiary form is simpler and more tax efficient. Trusts make sense in limited situations, protecting a beneficiary with special needs, a spendthrift child, or a complex blended family. But the trust must be specifically designed for IRA assets. A standard revocable living trust is almost never the right choice. The most important lesson: your IRA beneficiary designation is separate from your will and your trust. Whatever your estate planning documents say, the beneficiary form on your IRA controls where that money goes. Keeping those forms updated and coordinated with your plan is one of the most important things you can do. Your IRA beneficiary form controls everything. Make sure it is coordinated with your estate plan.